Welcome to this ad hoc episode of Law and Disorder. We're doing this because basically something has come up which we think really needs special attention. My name is Helena Kennedy, and with me is
Nicholas
Charlie
Mostyn.
Falconer.
More than 30,000 people in the UK were infected with HIV and hepatitis C after being given contaminated blood products in the 70s and 80s. A public inquiry has described the scale of the scandal as utterly horrifying. Doctors, government officials, the NHS, politicians, all of them were responsible and for failures to patients. The compensation scheme has been recommended, and just this week, our government announced that there would be sums of starting with £2,000 and £10,000 to each of the persons who had suffered and to their families. And the main patient groups involved in this were haemophiliacs, whose blood doesn't clot properly, and the others were people who were given blood transfusions because of health issues, often women who, after they'd had a difficult delivery of a baby. 300 children with haemophilia were infected, and all of them had bleeding disorders of one kind or another, and certainly we know that they suffered the consequences in having HIV or Hep C at some later stage in their lives. It should be known hepatitis C can lead to sclerosis of the liver and liver cancer. It has taken decades to become apparent the full scale of this. It's thought that 2,900 people have died, and that of haemophiliacs that 750 have died. And so it's been a repeated and repeated failure. Those in authority did not put the families or the patients first. So I really wanted to turn over to you, Nick. You're the person who did so much research on all of this for us. What do you see as being the main issues that are at stake here now for us, particularly as lawyers?
Well, I think as lawyers, we've got to try and get to the bottom of why there were these failures. The failures being an almost willful, as Sir Brown described it, blindness to the risks involved in giving this blood, which was known to be extremely risky. I mean, the fact is that the blood was imported in large quantities from the United States, where it had been paid for by people who were described in the report as being Skid Row derelicts, or from people in prison.
Why were we getting it from America? What was that about?
Because we weren't self-sufficient. That was the other problem. We did not. Our system for collecting blood was fragmented. It was disorganized, and it did not collect nearly enough. And so we had to import from abroad. But even the blood that we were collecting domestically was in large quantities coming from prisons. That didn't end until the late 1980s, according to the report. So the fact is that although the line was taken that it was the best treatment that was available, and with the implication that it was generally safe, it was known not to be safe. And this has been known for decades. And an inquiry we'll talk about this in more detail later, and inquiries were raised. Charlie will know about this because he was in government at the time during Margaret Thatcher's regime and the Tony Blair government. The idea of an inquiry for this ever-developing scandal was being debated, but no inquiry until 2017. And Charlie will be able to give some explanation as to why the government, which he was a part, resisted an inquiry so strongly. The fact is that compensation is now there has been one interim payment made of £100,000. Compensation is so late in the day, so many people are dead from as a result of this. But I think that the playing down of the enormous risks that have been taken with people's lives by importing what was known to be dangerous products is the most dreadful, terrible tale.
Indeed, I mean, I think the guts of it is that from 1970-ish through to 1990-ish, the government, the state, knew of the dangers of this particular blood. They did not tell people adequately about the dangers, and then the dangers were probably reduced to acceptable levels by 1990, and then they did not reveal what the government had been doing in effectively allowing people who had blood transfusions and haemophiliacs who relied on factor VIII and other things. They covered up all of the things that they had been doing, which involved placing these people at huge risk. And it is the process of the inquiry between 2017, when it was set up, and 2024, when it finally reported, though it produced interim reports that indicated the scale of what was happening. It's only the inquiry that has revealed both the extent of the knowledge that the government had of the risks that they were making patients take, and the extent of the cover-up that followed right up until the end of the inquiry. And really, I think the first question is, how did the government get away with it from 1970, in effect, to 2024 at one level?
Well, sorry.
Yes, Nick.
One of the reasons the government did get away with it is they engaged, as the inquiry points out in very understated but pitilessly remorseless language, is that they engaged in systematic document destruction to ensure that the evidence which would show what they knew wasn't available. I mean, it is when you read it, you think this is the government. This isn't some sort of ludicrous litigant, who's not complying with the rules of how to behave properly in some kind of inquiry. This is the government destroying documents which shows.
It's just
the underlying question, I think, for the government, and we can come in a moment to who we mean by the government, is but they were obviously thinking for a period, this is a good thing to do because more people will be helped than hindered. I think that was wrong. This is between 1970 and 1990. And then after 90, well, you say, well, this is the sort of terrible thing, like, well, we have a particular policy. It will lead to a certain number dying or being injured, but there will be a bigger number that will be benefited. That presumably is the thinking. And what the state generally does not do is indicate what the level of risk is. And that is one of these occasions. I think they got that calculation completely wrong, because they could have dealt with it in other ways. For example, they could have built our own voluntary blood transfusion system, which would have avoided all of these risks altogether. And if they had properly understood and then acknowledged the risks, they would have done it much, much more quickly than they did. And Brian Lanscarf, the chair and the author of the report, says if you'd really put your mind to it without too much effort, you'd have got to a self-sufficient voluntary blood donation system, as opposed to people who are being paid to give their blood, which was widely recognized as being much more risky. Instead of not getting there until the late 80s, you could have got there in the early 70s. But because they were not acknowledging the risk, there was no pressure.
Can I put my hand up? It's not a question of, I think you're being much too benign about government, and it's not government of different complexions. I think it was all about money. It was your age-old thing of follow the money. People, the idea that this would inevitably, by putting your hand up and saying that some terrible thing had happened, it meant that there would be, it raised the issue of liability. And so it was to avoid liability that people didn't fess up. And so I just want to go back to something. I had, and I don't know about others, but I had a really nostalgic idea about Britain and blood. That basically people donated their blood, that we were a nation in which there was that sense of civic responsibility and contribution, and that in Britain we gave it, whereas in places like the United States of America, if you had something that could be sold, then you would sell it rather than that you would give it. And so inevitably there was always the risk that those who would give it would be those who were indigent, those who were really hard up, those who had problems, those who were on the streets and so on, and that people would be giving blood who were there where there were serious risks attached to it. And it's not that people didn't know, because I saw and read that David Owen and is on record in the House as a member of Parliament and a doctor as saying there are high risks if we're going to be buying blood from the United States of America because they get paid for doing it, and there will be contamination. He warned people at the time and said, but if that's a risk that people are prepared to take, that's the way that we might have to go because we're so desperate for blood. So the people did know, Charlie. I don't think it was about people not knowing the sense of this, and I think that it was a risk that was accepted. And the consequences of it have been absolutely devastating. I really don't think this was about not knowing.
I think they didn't know, and I think one of the big complaints that Brian Langstaff makes is you never revealed what the true risks were. The government, in the sense of the National Health Service and the blood transfusion system, increasingly came to know, but they didn't tell the people to whom they were giving this treatment what the risks were. And one of the huge horrors that comes out of Sir Brian Langstaff's report is people being told without any awareness of the risks that they were undergoing when they went, for example, to get blood transfusions or another treatment if they were haemophiliac, or if they were getting blood transfusions when they, for example, had postpartum bleeding that was severe. They had no idea of the risk that they were taking. The state might have realized, but they didn't know. But on your first point, after they become aware of what's happened, what the government did, the state did between 1990 and 2024 is definitely very much underplay, which is putting it gently, what the level of risk was to avoid a massive bill for compensation.
It was always about trying to avoid having to pay compensation because they knew that as soon as the liability was accepted, there would be problems. And it's taken us, I think, a sort of acceptance, which we've discussed before about inquiries playing a greater role in our society, that where bodies of people, and here it was patients and their families, really start making demands on the systems, then an inquiry came into being, which has brought about this result. And it's like reflecting on the Bates thing with the post office and the Lawrence inquiry. Is how these things inevitably have to involve people saying we want justice, and they're right to be saying we want justice because it won't be handed out willy-nilly unless a demand is made. That's my whole experience of the kind of law that I've been involved in all my life, is that it almost always, in the end, to get this kind of change, the public needs to be able to make these demands and be encouraged to, and to have lawyers who will be vocal on behalf of them.
But what is so dispiriting is that the policy of successive governments was not merely to stay silent, but in fact positively to misrepresent. And so, for example, when it came to writing the report in 2002 about self-sufficiency, the author of that report put in it, he's called Peter Burgin, he put in that we knew about what is now called hepatitis C back in the mid-1970s. That was all crossed out. It's just taken out of this.
Yeah. I mean, the thing about it was that people did know these things, and they took risks with it. And nowadays, I mean, to reassure people about the state of play, since 1985, blood could be heat treated to eliminate, for example, HIV.
Yes.
And there's been much more testing of blood to make sure that the presence of Hep C isn't there, and that was possible from the 70s.
Yes, but that's important, very important point to make, which the report does make. It did not require any new technology to make the product safe. It didn't, none at all. It just required the blood to be heated, and that eliminated almost all of the risk. I mean,
I think all the risks were eliminated by 1990. As Nicholas and Helena's both rightly saying, there were ways of doing it. But in terms of the inquiry, Nicholas is rightly raising the question, why did it take so long? And Helena's saying it was in order to avoid compensation. And that I don't think they started in the early 70s with a desire to avoid compensation. The use of infected blood products, or the substantial risk, that was the position, was because they thought this was, quote, the best treatment. They soon become aware that it's not. And then the motive becomes for the state to avoid big compensation claims. But who are the state for these purposes? I don't think broadly that it was ministers covering up. I think it was a judgment being made by departments and primarily officials to the effect that if you reveal the suffering of the various people who have suffered, it's so intense it will have an effect on public opinion, whereas there will be billions of pounds spent on compensating the groups that have been affected, and that will then not be available for benefiting the greater good. And I think that motivation then leads to what is a pretty terrible cover-up. You saw the interchange with Ken Clarke, who's essentially a decent guy, who, when confronted with the words, "You said in a parliamentary answer, there's not conclusive proof that this can spread various infections. Infected blood there's not conclusive proof that it spreads infections." And he said, "Well, that's true, isn't it?" He said, and the inquiry concludes, "Well, it's true in a very technical sense that it isn't conclusive, but the level of risk is so high that nobody would give blood from that source to anybody sensibly." And the department knew that when they gave you that answer.
But can I ask you this? Tony Blair said and you were a member of the government at the time, in June 1999, "I'm not convinced that a public inquiry would provide greater insight into the problem or pave the way for any further improvements in the safety controls which are now in place." But it would have done. It obviously would have done.
Well, I'm not sure. I mean, he's making the technical point that by the time you get to 1999, for all the reasons that you and Helena and Nick, you have both said, the risk has gone. But that doesn't for one moment justify not having a public inquiry. What was happening by 1999 was not there needed to be safer means of getting blood donations and giving them, because by and large, as you've said, the problem had been solved. What was going on then, as Helena says, is the avoidance of damages was what the big issue was.
Yes, exactly.
Can I take us back to some of the questions that seem to come out of the inquiry for me? I mean, one of them, well, I mean, somebody, I can't remember which of you mentioned. I mean, why did the inquiry take so long? And I think that was partly because if you want to chase in an inquiry, you want to chase real, genuine information. It doesn't just pour out of people. You have to actually drag real information out of people. And as you said, Nick, a lot of the information had been destroyed, and so it takes time to get to truths often. And so, I mean, that's one of the inevitable reasons why inquiries take longer than anyone ever expects. But why? I mean, there was that question of suing for damages, because it's a question that you, Nick, have raised with us before. Is that why isn't there more use of the courts in the traditional way, rather than going for an inquiry? Why not be litigating? And there were, as I understand it, efforts at litigating, and some. And some litigation will continue, although there's going to be a compensation scheme, because there were children in a school where they were, I mean, these were children who did have haemophilia, and it was a school in which all the children had haemophilia, so there could be special protections for children who were really vulnerable, because if they bled, they could bleed to death. And they were being given platelets from these questionable sources brought in from the United States of America and pharmaceutical companies there. And there was never any consent obtained from the parents for what was really experimental treatment of those children. Right. And they ended up with HIV and AIDS, and they ended up, a child died when he was only 7. There's no wonder why parents would want to litigate the particular thing of the absence of consent and no inclusion of families in decision-making about some of this.
Yes.
And I mean, the question that you asked, Helena, which is a really important one, why not just deal with this through civil claims, which would reveal everything, to which I think the answer is absolutely crystal clear now that if there had been civil claims, they would have succeeded. But if what had happened, as indeed had happened over a very long period of time, the state had been completely closed down in giving full information about it. Imagine what the nature of that litigation would have involved. It would have been an incredibly difficult piece of litigation where many documents had been destroyed, where there was no clear picture until Sir Brian Langstaff's report revealed the whole picture. And it, in a sense, vindicates the process of a public statutory inquiry that only somebody with the powers of coercion, which you wouldn't have had until you'd started proceedings. You would be individuals in one way or another taking a huge risk, even if you could have found funding for this litigation. Every one of us around this table knows how incredibly difficult and stressful litigation of that sort is.
Government always contests these cases tooth and nail.
Absolutely.
I think it gives rise to a really interesting thing for us, as for any lawyers who are listening, but for the public too, which is that our justice system does provide opportunities for people to litigate and to sue someone who's done something, who they believe has wronged them. That those actions of themselves don't reach far enough into that which is systemic, which may have happened to numbers of people, and where the reach of the wrong goes beyond the individual case. Now, we know that in the United States they have these collective actions. They took them against the tobacco industry and all that sort of thing. That has been less of a thing that's done here. And the remedy that we have seemed to have disported ourselves to has been to go for the inquiry, this inquiry, expensive, it takes a long time, but which really unearths the full horror of something. And so we've seen it we saw it with Hillsborough, we've seen it with so many of these different issues, the post office, all these things where, suddenly you see the extent of it, and that would never come out through individual litigation. Charlie, what do you think?
I agree with that, but the trouble with it, I think, and I don't think there's much you can do about this, is the moment at which you appoint a public inquiry is very often when there is a political acceptance that something needs to be done. So these people, the people who suffered as a result of the infected blood scandal, had been suffering for years and years and years, and couldn't get sufficient traction to get a public inquiry appointed until 2017. And then it takes another 7 years before it happens. I make absolutely no criticism at all of Sir Brian Langstaff taking 7 years to get it, because if you read, and I haven't read all of it, I've read the first two chapters, and the first chapter
it's 50 years analysis.
And he's got so many topics to cover. And I thought, the power of the justice system is revealed in the reaction of those who had been affected by it to what Brian Langstaff had said in his report. There is a purgative and curative element to actually having somebody stand in judgment on the injustice that has been done to you. And it is incredibly important. But the big delay here is not 2017 to 2024. The big delay is 1970 to 2017. Yeah. And it brings us to another question where Brian Langstaff in his report says it shouldn't just be ministers who have the power to appoint statutory public inquiries. It should also be Parliament itself. Yes. And I was very responsible for the Statutory Inquiries Act in 2005, and 15 or 20 years later, I'm strongly of the view that Brian Langstaff is right, that Parliament should have the power to make the appointment. Of course, the government controls what happens in the Commons. The Commons have to agree to any statutory public inquiry, but where there is a massive scandal like infected blood or the post office, ministers will be much quicker to appoint public inquiries if they know they can have one forced upon them by the Commons, which they can't at the moment. And I think that change, which Brian Langstaff proposes in his report, is one we should definitely follow up.
Yeah, I want to endorse that. I agree with you. I think that I ended up doing an inquiry up in Scotland, which was around COVID and the impact on asylum seekers who were taken out of their accommodation and stuck in cheap hotels, and who all had suffered enormously because they were ripped away from places in which they'd formed a contact with a doctor, where they'd got to know sort of people, social workers in the area, and their neighbours, and they were suddenly kind of dispossessed of that too, and often had mental health consequences, and in fact led to the death of some people. But we tried to get an inquiry from the Home Office, and Priti Patel was having none of it. And so, if it's down to a minister and a particular thing, which is, immigrants, then you're not going to get very far with certain things. And so I do think that Parliament should be able to call for an inquiry when grave things happen as a result of certain actions. So I'm with that. I don't know what Nick feels.
Well, I do agree. I'd also come back to the delay. Charlie says the only material delay is, the one leading up to the, back in the 80s and 90s, the period. But I'd just like to say that the last 2 years before the publication of this report has been an example of iniquitous delay by the government in refusing to actually put into action its commitment to compensation in a period in which people have died. A lot of people have died. The government implicitly accepted back in May 2021, when Matt Hancock gave evidence to the inquiry, that it was going to have to pay compensation, and it had instructed Sir Robert Francis QC to work out a way in which compensation could be given. And he explained how it should be done in March 2022. And then that was all adopted by the inquiry in its second interim report, which came out shortly after that. But since then, the government has done everything it can to avoid actually putting its hand in its pocket and paying out the compensation. And it flatly refused to do it, even though there was no reason for this, because it was completely contrary to what happened with the post office. The inquiry is going on in the post office, but they're paying compensation. So we're not going to pay compensation until there's been the final reports. It's 2 extra years of delay when people have been waiting for this much needed compensation. And I just cannot, it almost makes one weep when you read about the heartlessness that is that particular delay has engendered.
And what we know is going to happen is now that this big bill, and rightly, that there should be serious compensation to all the people. But the big bill is going to be yet another addition to the great wretched financial situation that's going to meet any new government. And so I have only pity for those who are going to have to manage no money, and a nation that has so many deficits on so many fronts, and that includes, of course, in our court system and beyond. But I mean, it's just a shocker. I wanted to raise another thing, because what do we do about punishment? What about punishment?
Wait. On Nicholas's point, I completely agree that the government have behaved absolutely shamefully in refusing to provide a compensation scheme, even though they sort of promised that they would. I don't think that is a shortcoming of the inquiry system, because Brian Langstaff both produced a report relying on what Francis had said for compensation, and indicated that he wanted the government to comment on it, and the government indicated that they would until the very last moment. And this is after Brian Langstaff had revealed what his basic findings were in interim reports. The problem was the government playing fast and loose with the conclusions that the inquiry had reached. The inquiry is basically a very big success as an inquiry, because it reveals the truth, and what's more, it forces the government into a position where ultimately they commit themselves in Parliament to a compensation scheme, which is whatever it takes to deal with the problem. So it has worked in both revealing the truth and getting justice insofar as it's possible. The big delay, which has led to many people being dead before the inquiry reports, is not down to the inquiry, because it is the quality of the report that makes its strength so powerful, I think.
I would formalise what you both have suggested, to say that inquiries should not merely have the power, but should be encouraged, statutorily encouraged, to make interim recommendations for compensation, which the government should be required to accept.
Yeah. can I come in on the next
And when
thing?
I say required to accept, it should be required to consider.
Can
Yeah.
I just come in on the next thing, which is I'm it puzzles me that we presumably contracted with American pharmaceutical companies to get to buy this blood. Where there's sort of clauses in the contracts that said we will not be responsible for the quality of the goods that we're now selling you. I mean, there is an issue here because many people in the United States sued those pharmaceutical companies when they contracted HIV and AIDS and Hep C and so on from contaminated blood products, which were sold around America. So I want to know, why are we not seeking compensation from the people that we contracted with? Does anybody got an answer to that?
Well,
I think first of all, there'd be a very big limitation problem. If the infections were being spread before heat treatment, which comes in 1990, we're 34 years later. The people who would be making the contracts would be the various blood transfusion services in the UK. They would have known about the possibility pretty soon after 1990, if not before.
It was the heat treatment, Charlie, came in 1985. It was 5 years previously, and so it's not as late as you're suggesting. And I just don't understand. We were having these I'm sure repeat contracts with them. Surely, there's liability involved in that.
Well, I mean,
liability
Johnny makes a fair point about limitation, though, doesn't he?
You can't bring a claim now, 24 years later, on a contract basis. The risks. I mean, there are those claims that you referred to, which the victims in the UK brought, presumably against various National Health Service bodies, including the Blood Transfusion Service.
Mm-hmm.
They were negligent in various respects. They were stayed for the reasons I think I indicated earlier on, which seemed to me to be, we couldn't be sure that we would win. And if the public inquiry was going to get to the bottom of it, let's wait to see what the public inquiry says. And that judgment ultimately, although it took a long time to get to the conclusion, was probably the right judgment to make, because the consequence of the public inquiry's findings has been the government has now agreed to a full compensation scheme.
Let me just tell you that I was friendly with Anita Roddick. She became a friend of mine, and she had been told certainly in the 80s, she was given a blood transfusion after she had one of her babies, one of her daughters, and it gave her hepatitis C, and she knew that it was having a destructive effect on her physically, and so she was living with the idea that she would have a premature death, and it certainly probably affected her blood pressure, and she eventually actually had a brain hemorrhage. But I mean, she lived with that, and she knew it, and I think the toll that was taken on the lives of people living with the proximity of death, it was so shocking, and I just feel that it was criminal. And you're saying that things we didn't know about heating. Well, certainly that was 1985. That if you heated, you could destroy the HIV virus. But testing for the presence of Hep C could have happened in the 70s. We just didn't bother to do it.
Yeah,
can we just focus on Helena's suggestion a little earlier, that there should be some kind of criminal sanctions for people who allowed the use of products, one of which is described in the report as having a 90% chance of giving you hepatitis, and they knew it and they kept quiet about it. And why is this not, when somebody dies, why is this not manslaughter? There's no limitation period for that.
Well, I think there seem to me to be the possibilities of criminal charges. The three sort of criminal charges seems to me to be the possibility of the sort of physical injury or manslaughter type charges.
Well, I mean,
but all of this would have occurred before any sort of corporate manslaughter could get off the ground. So individuals would need to be identified, and I found it very difficult. And I've only read the summary in volume 1. I haven't gone into the detail of apart from volume 2, volume 3 to 7. are there identifiable
Yes, in
people?
volume 7, I've read volume 7, and there are identified, but I don't know enough about criminal law. I mean, Helena, I mean, why would this not be why would these not be criminal acts?
Well, I mean, I think there is an issue about corporate manslaughter. I mean, there isn't a very good record on corporate manslaughter being successful because it's that whole business of to what extent can you attribute knowledge to those at the top end of things. But I definitely think there should be an investigation into criminal responsibility. I really do. I think this is so disgraceful. Now, many of those people who are making those decisions back in the 70s are probably dead now.
Yeah.
Because the people at the senior level would not are probably no longer alive. But I still think that there should be an investigation because you need to be. I want us to be reminding and telling people that these responsibilities do have consequences and that they will have personal consequences, which could be of a criminal kind. And I think that that message should be reaching into the corporate world.
Well, I do agree with you. I did watch the video of Sir Brown presenting his report, and the people who were affected were cheering him to the rafters. And I did feel that at last there had been a moment when they felt that they had received some recognition. And I will say, I've read volumes 1 and 7 of his report. I haven't read any more. It is a most arresting and compelling read, and it is really, really well expressed. He uses sort of litotes, dramatic understatement, absolutely in a devastating way. And so one thing about public inquiries you've said before, Charlie, is that victims almost never get a proper sense of justice. But I actually felt that the victims here at least will have this record, which does tell the whole story.
Well, listen, we're about to have, I mean, in September, when there will be a new government, whether a return of Conservative government or whether it's a Labour government or whatever, there is going to be a new settlement, and there's going to be the Grenfell inquiry's report, and I suspect it's going to be devastating, and I suspect it is going to be calling for corporate responsibility for failings. I mean, I'm guessing because I wasn't part of it, and I just think that having sort of followed it reasonably well, I think that there's going to be some serious demands from the people who've suffered and lost their family members and so on, that there were failings of a grievous kind, and we will see.
I think definitely, but I mean, there was a big change in corporate manslaughter law in, I think it's 2008. But isn't the issue here, if we're talking about corporate manslaughter as opposed to the cover-up, the corporate manslaughter charges would relate to what happened pre-2008 and certainly pre any change in the law that comes about with a new government, if there is a new government, and it won't have retrospective effect. And what the effect of it will be, you've got to... The old corporate manslaughter law is effectively you've got to have the actual board of directors if it's a private company, or the minister and the most senior people involved doing it deliberately for the corporation to be
so
responsible.
Hard.
It's been that's been relaxed. It's relaxed so going forward.
You really needed knowledge, I mean, our mens rea is an issue in it, and so it has been problem, and even in modernizing it, one has sought to sort of maintain that high level of the evidential threshold is high, so it's a very interesting, serious thing. So, well, I'm glad that we came together, albeit on a bank holiday, in order to sort of cover this. And but I think it merited a visit by us to a really serious topic. Yes, well, thank you all. I thought it was great that we came together. Is there anything, Nick, that you would like to add as our judicial colleague?
No. I think it's all been covered very thoroughly. It hasn't been one of our more light-hearted episodes.
No,
it has been somber and serious. And I, for my part, would just like to pay tribute to Sir Brian and his team for writing an excellent report and express my sympathy to the victims, the extent of their suffering, and what I had no idea until I read the report. And it was
a terrible story.
So it's goodbye
Thank
from me.
You all.
I completely agree. Thank you, Helena. Thank you, Nicholas. Bye-bye.